Circumstances under which an attorney can fire a client. It's any. It's a consensual relationship. Some attorneys forget that. But if you're not getting along with that client, if they're not listening to your strategy, if they're not paying you, you can fire that client. And sometimes that's a very good thing, especially for staff morale, especially where a client is abusive to you or to your staff. I know attorneys who routinely give a Christmas present to their staff by firing one difficult client every year. So now the question is, when must an attorney fire a client? And the answer to that is when they've offered false evidence. If they've offered false documentation, if they're trying to elicit false testimony, you are required to talk to the client, ask them to retract that statement, identify it to the court, and try to mitigate that. If they're not going to do that, your job is to withdraw. And we use what's called a noisy withdrawal, where you let the court know that you are withdrawing, you don't want to tell them why. But that is important because you do not want to be a sponsor of false evidence. And once you know it's in there, you have a duty to either get it out or get yourself out. First steps when an attorney is going to fire a client. What I recommend is take time, write out why. This is your time to reflect, think about many of the reasons why you want to fire that client. Put it in a letter form. Then you're going to be able to use that during a phone conference with that client. You don't want to just send the letter, you want to also have the phone conference, because one of the things you want to do is offer that opportunity to the client so that they can go out and get substitute counsel. Because what I tell my clients is, I don't want to file a withdrawal. I'd much rather file a notice of substitution of counsel. Go get someone else, because I'm not going to be your attorney anymore. There are going to be 2 letters that you're going to provide to the client. You're going to talk about them during that phone conference. Tell them that one of the letters is going to explain all the reasons why you're firing them. The second is an exhibit that you're going to attach to your motion to withdraw. In that 10-day letter, you're going to give written notice to the client that you're withdrawing. You're going to say, for the reasons stated in my letter dated March 8th, I'm withdrawing. You're giving them 10 days notice, you're referring them to other counsel, you're encouraging them to get other counsel. So if a judge doesn't want to let you out of a case, that's going to depend on what the situation is. If you're trying to get out of the case on the eve of trial because the client isn't paying you, that's going to be difficult. The judge is not going to want to let their docket get affected. On the other hand, if they aren't paying you and there is time, you're going to file your motion. If the judge denies it, you can appeal it. There is 7th Circuit case law reversing a trial court and requiring that trial court to allow an attorney to withdraw. So there is precedent out there. If you've got the right provisions in your contract, you can get out of that representation if the client has consented. So some of the contractual provisions you want to include in your engagement letter. A requirement that the client truthfully inform you of all the circumstances in the case. The other thing is that it's a material term of the contract that they pay you timely. What I put is that the client is required to pay me within 30 days of the invoice. What you could put is also language that says, by signing this agreement, client consents to the attorney's withdrawal if client fails to pay the invoices in full within 30 days of receipt. If you have that provision, you can attach that as an exhibit to your motion to withdraw if the client isn't paying you. Tips for maintaining a healthy attorney-client relationship. It's communicate, communicate, communicate. What I try to do is, even in a case that I'm not touching, I want to reach out to the client every 30 days, generally speaking, when I do my billing. Even if I don't have a bill for that client, I send them an email saying, there's nothing new on your case. Providing regular communications of what's going on, I think, is the most important thing. And then secondly, you want to provide regular, every 4 or 6 months, updates on the status of the case. You want to discuss objectively strengths and weaknesses in your case, strengths and weaknesses in the opposing party's case. You want to talk about what are the likely outcomes or results, what are the likely costs. And you want to talk about goals. I think that it's important to discuss goals and set goals early on in the representation and get that in writing and memorialize that we discussed that your goal was a pre-suit negotiation, but it didn't work out. So now we have to move forward with litigation. You want to discuss those things and make sure that you're on the same page.